All right, welcome back. Hopefully I've got a fun one for you today. Brand new case, literally brand new, filed yesterday on the 24th of May. And while it's a brand new case, it could be a mirror of a case we've already seen. Frankly, it's so. This is Floyd Wallace versus the Las Vegas Metropolitan Police Department. Floyd Wallace, as I'm sure most of you who are here know, he goes by the YouTube name News Now Omaha. I prefer to call him News Now Itchy Back, News Now Passport Bro, News Now Marionette for PayPal Patty, or unfortunately News Now Future Statistic, because just the way he's going, I think at some point he's going to eat lead, unfortunately. I don't want it to happen, but just his actions around police, it's inevitable. So why do I say we've seen this case before, even though it's brand new? Well, I have a feeling that the complaint was written by Jose de Castro, Delete Lawz. Um, it's no coincidence that Floyd targeted the same police precinct where the officers who arrested Delete Lawz are stationed. So it I hesitate to say conspiracy, at least not in the criminal sense, but uh, there's something fishy. And like I said, I have a feeling that Delete Lawz wrote this complaint. I have not read it yet. I've literally seen the first line of the complaint, so this is a complete blind read, first read. Um, you're getting my reaction, but just from that first line, plus what I've seen other people say about it leads me to believe Delete Lawz wrote it. So as we're going through, I want you guys to keep an eye, because if you're here, I'm assuming you've seen the video that I've done or that Merb has done or read it yourself. Delete Lawz website against the LVMPD. So I want you to look for similarities, basically, is what I'm saying. With that, let's jump into the case. It was a fairly long video yesterday. You're getting two days in a row, probably three in a row, because even though I've slacked on the California case, I kind of want to read Blue Bacon's anti-slap motion, so I'll probably do that tomorrow night. But that being said, let's jump into it. As always, start with the docket. Wallace versus Las Vegas Metropolitan Police Department, filed yesterday, randomly assigned to Judge Andrew P. Gordon and Magistrate Judge Nancy J. Copy, or however that's pronounced. And we have the complaint, docket number 1, along with the civil cover sheet, summons, certificate of interested parties. The only interesting part of that is going to be the complaint, really. And then we have the advisory letter to the litigant, basically saying, you're pro se. That means you're probably dumb. Are you sure you want to do this? So all we're going to look at today is the complaint. And with that, let's jump over to the complaint. So we have our first similarity: Floyd Wallace, plaintiff, versus Las Vegas Metropolitan Police Department, State of Nevada, Christian Torres, Jason Shoemaker, Corey McCormick, and does 1 through 50 inclusive. That's a favorite tactic of Delete Lawz. Does 1 through 50 inclusive. I have a feeling it's going to be the same dose for failure to train, whatever he claimed in his case. And it's a complaint for damages and demand for jury trial. Introduction. Like I said, I've read the first line. Plaintiff, a black member of the press who specifically records police interactions, was recording a police officer interaction outside the Spring Valley Command Substation in southwest Las Vegas, Nevada. Does that not read, other than a black member of the press? Didn't Delete Lawz open his? Plaintiff, a member of the press. As if being a member of the press exempts you from laws. And being a black member of the press doubly exempts you. I mean, yes, there are problems with racial policing, basically. But that doesn't mean every arrest of a minority is problematic. In this case, I'm going to just state it on the record right at the beginning. There was probable cause to arrest Floyd. There just was. He was wearing a ski mask, and I'm not talking ski goggles. It was the knitted ski cap, I believe, like I have on, but with the holes for your eyes and mouth. It basically, it's short of wearing pantyhose over your face. It's the favorite mask of robbers, of burglars. He wore it in very hot Las Vegas, Nevada, with the specific intent of causing alarm in the police, making them think, to use the words of Delete Lawz' favorite case, Terry versus Ohio, he was casing the joint. So, of course, police thought he was up to something. They had probable cause. Now, did they need to arrest him? No. It's my understanding even that the prosecutors have already declined to prosecute. But that hasn't been made official in court yet. So this might be jumping the gun on Floyd's part and giving the prosecutors incentive to prosecute. So continuing on with sentence 2, 3 Las Vegas Metropolitan Police Department officers, including a supervisor, without reasonable suspicion that the plaintiff was involved in any criminal activity, did interfere with and rob plaintiff of his liberties while he was in a place that he was lawfully allowed to be, while plaintiff was performing constitutionally protected activities. The officers used excessive force, detained plaintiff, handcuffed, arrested, and searched him and his possessions. None of the defendants intervened to prevent the unreasonable detention, arrest, or searches. Sadly, the abusive treatment plaintiff endured for merely asserting his rights while black, Jesus Christ, and recording the police is not unusual or surprising. This civil rights action seeks to vindicate plaintiffs' constitutional and statutory rights and hold the officers and their department accountable for biased policing practices and the policies, or absence of policies, that resulted in these practices. Parties. Plaintiff Floyd Wallace, or plaintiff, is an adult over the age of 18, a member of the press, and at all times relevant hereto was and is a resident of the state of Texas. I think individual would have covered all of that, but Delete Lawz has to pontificate. Defendant, Las Vegas Metropolitan Police Department, LVMPD, is a quasi-municipal entity and a political subdivision of the state of Nevada, created and regulated by NRS Chapter 258, and at times relevant hereto employed all of the individually named defendants. Remember how Delete Lawz called the LVMPD a quasi-municipal entity? I sure hope that the Nevada State Bar Association is aware and opens an investigation into Delete Lawz for practicing law without a license. Defendant, State of Nevada, is a government entity and at all times relevant hereto operates, oversees, and manages defendant LVMPD under the color of state law. Not really. The state of Nevada, I mean, the LVMPD, yeah, it's a political subdivision, but it's not operated by the state of Nevada. That's ridiculous. Defendant Christian Torres is, and at all relevant times was, an officer with the LVMPD. In doing the things herein alleged, Torres was acting under the color of state law and in the course and scope of his employment with Nevada. Torres is sued in his individual capacity, including in his capacity as a supervisor. He's not an employee of the state of Nevada. Defendant Jason Shoemaker is, and at all relevant times was, a supervisor with the LVMPD. In doing the things herein alleged, Shoemaker was acting under the color of state law and in the course and scope of his employment with Nevada. Shoemaker is sued in his individual capacity, including in his capacity as a supervisor. His individual capacity is not as a supervisor, though. That doesn't make sense. That just doesn't make sense. Defendant Corey McCormick is, and at all relevant times was, an officer with LVMPD. In doing the things herein alleged, McCormick was acting under the color of state law and in the course and scope of his employment with Nevada. McCormick is sued in his individual capacity, including his capacity as a supervisor. Are all of them actually supervisors? I mean, the only one, because see, Torres, it says an officer. Shoemaker, it says a supervisor. McCormick, it says an officer. Yet all of them are being sued in the capacity of a supervisor. That doesn't make sense. The true names and capacities, whether individual, corporate, associate, or otherwise, of defendants sued herein as does 1 through 50 inclusive, are unknown to plaintiff, who therefore sues said defendants by such fictitious names. Plaintiff will amend this complaint to show the true names and capacities if and when the same are ascertained. Plaintiff is informed and believes and thereon alleges that said defendants and each of them are responsible in some manner for plaintiff's damages as herein alleged. Each reference in this complaint to defendant, defendants, defendants, or a specifically named defendant also refers to all Doe defendants. Isn't that convenient? And we all know one of Delete Lawz' favorite tactics for prolonging litigation, but putting off discovery because he's terrified of discovery, is amending complaints. That's, to him, that's litigation. Plaintiff is informed and believes, and thereon alleges, that each of the defendants sued herein was negligently, wrongfully, and otherwise responsible in some manner for the events and happenings as hereinafter described, and approximately caused injuries and damages to plaintiff. Further, one or more Doe defendants was at all material times responsible for the hiring, training, supervision, and discipline of other defendants, including the individually named and Doe defendants. Hey, isn't that the same theory Delete Lawz has for including 50 Doe defendants in his case? Plaintiff is informed and believes, and thereon alleges, that at all times herein mentioned, each of the defendants, including all defendants sued under fictitious names, was the agent and or employee of each of the other defendants, and in doing the things hereinafter alleged, was acting within the course and scope of such agency and employment. Plaintiff is informed and believes, and thereon alleges, that at all times herein mentioned, each of the defendants, including all defendants sued under fictitious names, was the agent and or employee of each of the other defendants, and in doing the things hereinafter alleged, was acting within the course and scope of such agency and employment. Plaintiff is informed and believes, and thereon alleges, that each of the defendants was at all material times an agent, servant, employee, partner, joint venturer, co-conspirator, and or alter ego. Seriously, alter ego of the remaining defendants, and in doing the things herein alleged, was acting within the course and scope of that employment. Plaintiff is further informed and believes, and thereon alleges, that each of the defendants herein gave consent, aid, and assistance to each of the remaining defendants, and ratified and or authorized the acts or omissions of each defendant as alleged herein, except as may be hereinafter otherwise specifically alleged. At all material times, each defendant was an integral participant, jointly engaged in constitutionally violative, unlawful, and or tortious activity, resulting in the deprivation of plaintiff's constitutional rights and other actionable harm. At all material times, each defendant acted under color of the laws, statutes, ordinances, and regulations of the state of Nevada. Jurisdiction and venue. This court has jurisdiction over this action pursuant to 28 U.S. Code sections 1331 and 1343 A3 and 4, because it arises under the Constitution and laws of the United States, as it is being brought to obtain compensatory and punitive damages for the deprivation under color of state law of the rights of a citizen of the United States that are secured by the United States Constitution, pursuant to 42 U.S.C. sections 1981, 1983, and 1988. This court has supplemental jurisdiction over the claims arising under Nevada law, pursuant to 28 U.S. Code section 1367A. This court is the proper venue pursuant to 28 U.S. Code section 1391B2, because the events giving rise to the claims occurred in the county of Clark in Nevada, which is in the U.S. District of Nevada. General factual allegations. At approximately 6:02 p.m. on May 10th, 2023, plaintiff was in the parking lot of the LVMPD's Spring Valley Command Substation at 8445 Eldora Avenue, Las Vegas, Nevada, a public place where plaintiff was legally allowed to be, video recording a police interceptor enter a vehicle gate marked police personnel only. Once the interceptor entered the restricted area, plaintiff walked closer to the open gate and stopped on the public side of the gate near where the gate would close. After plaintiff had stopped on the public side of the gate and was filming, a man in street clothes exited the police interceptor vehicle and asked plaintiff what he was doing. Plaintiff did not answer, and the man told plaintiff that it was a restricted area behind the gate, which was obvious based on the sign. When the gate was almost done closing, plaintiff moved his camera closer to the gate, but remained clearly behind the gate and recorded for approximately 10 more seconds before leaving the area and returning to the public sidewalk. Plaintiff never said or did anything that would have led a reasonable law enforcement officer to fear for their safety or to suspect that plaintiff committed or was planning on committing any crime, other than wearing a mask. And no, it wasn't a face mask to prevent the transmission of bacteria or a virus. It was to conceal his identity, because the type of mask, the type of ski mask he was wearing in Las Vegas in the heat of the desert, you would not wear for any purpose other than to conceal your identity. And to do so while approaching a restricted area, that's suspicious. It's very suspicious. But let's see if Floyd mentions any of that. While plaintiff was walking on the public sidewalk away from the police station, he heard a siren coming from the direction of the police station go off for approximately 10 seconds and then stop. Approximately 10 seconds later, at 6:04 p.m., plaintiff heard someone yelling behind him. A few seconds later, someone yelled, "Police, stop!" Plaintiff immediately stopped and witnessed a police officer walking toward plaintiff with a gun drawn and a second police officer in a police interceptor with lights on driving toward plaintiff. Plaintiff protested the unnecessary drawing of a gun and voluntarily walked to the officer's interceptor, where the officers seemed to want to illegally detain plaintiff at. Well, that's just good grammar. And I don't think the officers wanted to illegally detain plaintiff at their interceptor. Plaintiff continued to assert that the police officers were violating his rights while they handcuffed plaintiff. Once handcuffed, plaintiff asked what he was being detained for and was told reasonable suspicion. One of the officers said that plaintiff was on camera trying to go into one of the gates. Plaintiff continued to assert that he had broken no law and that he was in a public area. One of the police officers asserted that the parking lot was not a public area by saying, "Public area in the parking lot? Dude, that's where employees go in." Plaintiff continued to assert that he had broken no law and that the officers were violating his rights, at which time one of the officers began to ask plaintiff for identification while a different officer patted plaintiff down. In order to prevent an immediate search of his wallet, plaintiff was required to assert his right to not have his wallet searched. Soon after, one of the officers told plaintiff to stop being disrespectful. The audacity. Plaintiff refused to answer questions about his identity and asked for a supervisor. One of the officers said, "Here I am." Obviously, if a supervisor is already there and violating plaintiff's rights, plaintiff was requesting that supervisor's supervisor, but none was dispatched. First off, it's not obviously. That's poor legal writing. But as we know, there is no law requiring any supervisor on the scene. A rookie patrol officer can make they can make an arrest. They don't need the supervisor there. The rookie officer can make the arrest. It's not invalidated by the lack of a supervisor. Some jurisdictions have a policy that if it's requested, yeah, get a supervisor. But there's no requirement that you've got to get a lieutenant or a captain and as we all know, because First Amendment auditors love to say policy isn't law. So how are his rights violated by not getting the supervisor's supervisor? Soon after, one of the officers accused plaintiff of wearing a mask, to which plaintiff answered, for COVID. Not that kind of mask, though. Soon after, one of the officers said that if plaintiff didn't identify himself, that plaintiff was obstructing their investigation and that plaintiff was going to jail for that. Plaintiff was forced to provide his name and birthday under threat of arrest, after plaintiff was again accused of being disrespectful by one of the officers. While still being detained, plaintiff was told that if he didn't do what the officer said, that he was going to jail. Anytime after I have to readdress you, after I've given you a lawful order, you are obstructing my investigation, one of the officers said. Plaintiff continued, and obstruction isn't just physical resisting. If you are required to do something as part of an investigation, such as giving your ID, getting handcuffed, sitting in the back of the police cruiser, refusal can be obstruction. Plaintiff continued to assert that the officers were violating his rights, and one of the officers continued to say that if plaintiff hindered their investigation, that he would be arrested. The officers continued to accuse plaintiff of being suspicious for wearing a mask while in a parking lot, and that plaintiff was being detained for suspicion of auto theft. I don't remember that on the video. I'm not saying it isn't there, but I don't remember them accusing him of auto theft. Maybe casing the parking lot to steal something in the future, but and we know from Delete Lawz' favorite case, Terry versus Ohio, remember, Mr. Terry did not rob that jewelry store. He was suspected of casing the jewelry store. And the Supreme Court said, yeah, that's enough. That's enough to detain him. And, you know, you saw a bulge. And so doing that pat down was justified. And you found the illegal gun. Hey, good arrest. Good job. And I just looked ahead in the paragraph and it references Terry versus Ohio. The officers engaged in profiling against Black people when they likened plaintiff standing outside of a police station exercising his First Amendment rights while wearing a mask to Terry versus Ohio, where Officer McFadden patiently observed 3 Black men walk past and peek into the window of a jewelry store a dozen times over a period of an hour until McFadden had reasonable suspicion. But Terry wasn't wearing a mask to conceal his identity. So it doesn't take a dozen peeks and an hour time period to establish reasonable suspicion. That's ridiculous. It's the totality of the circumstances. Would if Floyd had not been wearing a mask, but he had been otherwise pacing for an hour, peeking in and looking in cars and just loitering in the parking lot, would they have had reasonable suspicion? Maybe. But wearing a mask to conceal his identity, hey, that puts off alarm bells a lot quicker. Soon after, one of the officers said, "Of course I'm going to pull my gun on you because you're not obeying our commands to stop, in violation of LVMPD's use of force policy and interactions with the public policy." Policy isn't law, as frauditors like to tell us. And where's the policy? Show us the policy. Yesterday, in the video I did discussing Delete Lawz, well, the Google's response to Delete Lawz, this is a conclusory statement. This isn't stating a claim upon which relief can be granted. This is a mere conclusory statement. A legal nothing. Plaintiff continued to assert his rights while an officer threatened to call an ambulance for mental help on the plaintiff, which would deny him of his liberty. Next, an officer threatened holding plaintiff for resisting and terroristic threats. Soon after, one of the officers said, "I don't want a terrorist in my parking lot." At approximately 6:15 p.m., one of the officers said, "I have the right to detain someone that is acting suspicious." True. Plaintiff asserted that he wasn't being detained for suspicion of an articulable crime, but rather suspicion alone. Trespassing, loitering, attempted burglary. Need I go on? Plaintiff acted to assist in the investigation and clear up any suspicion by explaining he was exercising his freedom of the press and working on a story to see if the police would respect his rights. At least one of the officers did understand that plaintiff was a First Amendment auditor, and that same officer expressed that exercising the freedom to record police interactions while wearing a mask is suspicious of a crime on its own. Soon after, plaintiff was accused of baiting the police officers by one of the officers. Exactly. These officers are not dummies. That they're not stupid, and especially this is the same precinct that Delete Lawz has been harassing for the last 2 months. I think 2 months, roughly. So, of course, they know that he's a First Amendment auditor and that he's baiting them. Do you think they haven't been briefed, though? Like, if not the entire LVMPD, at least this substation, do you think they haven't been briefed? And part of that briefing was, this is the line. If they cross this line, go ahead and arrest. I bet they've done that. Plaintiff continued to assert his rights and his innocence. And at approximately 6:33 p.m., plaintiff asked, "Am I being arrested?" but was not answered. Plaintiff continued to ask if he was being arrested and for what. Fun fact, police don't have to tell you anything. They don't have to tell you why you're being arrested. You can find that out at arraignment. It's a better practice to tell you, but sometimes it just makes sense to wait until you're handcuffed to the wall at the station. After the officers refused to answer several times, plaintiff was arrested for attempted trespassing at 6:40 p.m. after being detained for 36 minutes. All the defendants on the scene knew that there was no reasonable suspicion or probable cause to suspect plaintiff of any crimes, but wrongfully believed that they were justified in detaining and arresting plaintiff for assertion of his civil rights. That's more conclusory statements, and it's even it's crystal ball conclusory statements. It's this is what the defendants knew. How would you know what they knew? Plaintiff was searched and transported to the Clark County Jail, where he would not be formally charged, but only released with a citation. The citation is the charge. If you received a citation, you were charged. Now, the prosecutors might not take up that charge, which at this point I believe is going to be the case, but this lawsuit might have changed that. But he received a citation. He was not released without charge. He was cited. Meaning, he wasn't formally charged. Well, that means, hey, they didn't hold you until you were brought before a magistrate. You just received a citation and were cut loose. Hey, it's almost like they were doing their best not to violate your rights, to be the least restrictive, to cause the least disturbance to you. As a result of the defendant's actions, plaintiff suffered a deprivation of his rights and liberties, suffered mental suffering, emotional distress, fear, embarrassment, and other general damages in an amount to be proven at trial. The defendant's behavior did not follow LVMPD's use of force policy and interactions with the public policy. Plaintiff is informed and believes and intends to prove after conducting relevant discovery. What do you think? Is Floyd as terrified of discovery as Delete Lawz is? We'll see. Well, we probably won't see because I have a feeling this is dismissed well before it gets to discovery. But he believes that and intends to prove after conducting relevant discovery that defendant's actions in detaining and or arresting plaintiff, using force on him, and illegally searching him and his belongings was motivated largely or entirely by the following. 1. Plaintiff's position as a member of the press that records police interactions for accountability and that was engaging in his First Amendment protected activity. 2. Plaintiff's negative political viewpoint of police. I don't recall him stating that political viewpoint at any point during his interaction with them. So unless the police also have a crystal ball to figure out Floyd's thoughts, how would they arrest him on something that they don't know? 3, plaintiff's skin color. No. And or 4, plaintiff's verbal protestations of the defendant's actions and plaintiff's accusation that the defendants were harassing him. Indeed, as shown on the video footage captured by plaintiff's cell phone and the video footage plaintiff expects to obtain from the defendant's body cams, plaintiff did not do or say anything that would have provided reasonable suspicion or probable cause for the excessive force used, detention and or arrest, and subsequent searches. Therefore, there is a strong inference that the defendants were in fact motivated by one or more of the 4 factors enumerated above. And I'm curious. I know Artie of Artie's Corporate Fiction through viewer generosity, thanks to all of you guys. Artie obtained the body camera footage for Delete Lawz arrest. I don't know if he's fundraising for Floyd's arrest or not. I know he mentioned that it was a possibility when it first happened, but I I don't know if anything's come of it. I assume that this would be cheaper body camera since it's only 3 officers, but we'll see. First cause of action, 42 USC Section 1983, Fourth Amendment, against Torres, Shoemaker, McCormick, and Doe's 1 through 25, even though he's suing Doe's 1 through 50. If I recall, Delete Lawz on the first cause of action only went with the first half of the Doe defendants. Do we still think that Floyd wrote this himself? Or did Delete Lawz engage in the unauthorized practice of law? Plaintiff refers, blah, blah, blah. By the actions and omissions described above, the defendants, acting under the color of state law in their individual capacities and as integral participants, violated plaintiff's rights under the Fourth Amendment to the U.S. Constitution and equivalent rights under the Nevada State Constitution. And I notice he says acting under the color of state law in their individual capacities. So they're only acting in their individual capacities. This could be a problem. I mean, the whole thing's a problem. I think there's probably a first step you've got to take before suing the state that I highly doubt that Delete Lawz and Floyd have undertaken in either of their cases. And frankly, I wonder if the same random gray-haired woman in the lobby is going to be served with Floyd's case. Because as far as I know, the state of Nevada has not been served. Well, no one has been served, I should say, in Delete Lawz case. So these deprivations include, but are not limited to, the right to be free from detention without reasonable suspicion, the right to be free from arrest without probable cause, the right to be free from unreasonable search and seizure of property, the right to be free from excessive force and unreasonable force in the course of an arrest. And it's like, I believe there was probable cause for the arrest. Like I said, I don't know that an arrest was necessary, but I do absolutely believe that there was at least probable cause for the arrest. Without a doubt, there was reasonable suspicion for the detention. That's a really low standard. Frankly, probable cause isn't a very high standard. It's lower than preponderance. And preponderance is slightly above 50%. So probable cause is lower than that. And in order for your rights to be violated, some people, like sovereign citizens and First Amendment auditors, believe, hey, if I wasn't convicted or I wasn't charged, it was a bad arrest and I can sue. Well, that just means that there wasn't reasonable doubt. That standard wasn't met. As long as the probable cause standard was met, the case is a nothing burger. Defendants subjected plaintiff to their wrongful conduct, depriving plaintiff of rights described herein, knowingly, maliciously, and with conscious and reckless disregard for whether the rights of plaintiff would be violated by their acts and or omissions. Defendants' acts and or omissions were the moving force behind and approximately caused injuries and damages to plaintiff as set forth above. Defendants' conduct entitles plaintiff to punitive damages and penalties allowable under 42 USC Section 1983 and Nevada law in an amount sufficient to punish and deter such conduct. No punitive damages are sought against Nevada. Now, funny enough, well, I highly doubt that News Now future statistic, Floyd, I highly doubt he approached civil rights attorneys. Just in general, I doubt, especially since I think that this was a setup along with Delete Lawz, with the understanding that Floyd would do whatever it took to get arrested for some petty thing and they'd sue. So I doubt it was ever planned to even approach an attorney, since this was Delete Lawz' plan, I'm sure. But just as an aside, if your rights were violated, your civil rights, and you have a legitimate Section 1983 civil rights lawsuit, do you know what you don't do? You don't bring it pro se, because do you know what? Attorneys, real civil rights attorneys will take the case. They're not going to charge you if they think it's a good case, because under 1983, and I believe the payment statute is 1988, if you win your civil rights case, the government's going to pay your attorney. So if Floyd had a real case that a real civil rights attorney believed in, they would have taken the case happily. Of course, he would have had to, number one, approach actual civil rights attorneys. But number two, he'd have to have an actual case. That's the real problem here. So, second cause of action, 42 U.S.C. Section 1983, 14th Amendment, against Torres, Shoemaker, McCormick, and Doe's 1 through 25. By the actions and omissions described above, defendants acting under color of state law in their individual capacities and as integral participants violated plaintiffs' rights under the Equal Protection Clause of the 14th Amendment to the U.S. Constitution and equivalent rights under the Nevada State Constitution. Defendants intentionally discriminated against plaintiff based on the color of his skin, his position as a member of the press, and due to his political affiliation and viewpoints. Political affiliation? Where did that come up in the arrest? Defendants would not have harassed, detained, arrested, used force on, and searched plaintiff if he had been more like them. You mean a police officer in a police officer parking lot? More like them like that, perhaps? In particular, according to defendants' own statements, one of the facts upon which they relied in detaining and or arresting plaintiff is that there were previous incidents involving suspicious-looking black people. Where was that statement made? I didn't hear that statement. That it's a conclusory statement for starters, but where? Did they say there were incidents involving suspicious people wearing masks? Seriously? Choosing to detain plaintiff, a black member of the press, based on alleged actions and or involvement of others due to their skin, due to the color of his skin, is illegal profiling and prohibited by the 14th Amendment's Equal Protection Clause and by NRS 289.510. If the defendants had been told that a man of their skin color trying to get police officers' autographs instead of photographing police interactions for accountability had been in a place where he was legally allowed to be, it is virtually certain that defendants never would have detained, arrested, or searched such a person in the same parking lot in the same location. Well, for starters, would they have been wearing a face mask and appearing to case the joint? And I'm guessing if a black person with a camera had gone up to the gate, not wearing the face mask, not obstructing his identity, but if they had gone up to the gate and called out to the officer, not silently skulking there, if they had gone up and called to the officer, "Hey, can I get a picture with you and your autograph?" No, he wouldn't have been arrested because the officer would have known what he was doing there. It wouldn't have been suspicious. I mean, so this wasn't in the U.S., but when I was in the UK in 2007, so this was my second time in the UK, but basically I was spending like 5 days in London before traveling up to Durham to start my master's program there. So I'm outside of Parliament, and basically I'm just doing the London touristy things. And there's a London Metropolitan policeman in his full uniform, and I wanted a picture because, hey, I'm in London and it's an interesting uniform. I didn't have to, but I called out to the officer. I said, "Hey, is it all right if I get your picture?" "Sure, go ahead." I wasn't arrested because I was polite. He knew what I was doing. I was allowed to do it. I was on a public sidewalk. He was behind a fence. He was in a restricted area. But there was nothing suspicious about what I did. I wasn't wearing a ski mask. I wasn't casing the joint. This is easy stuff. Defendants subjected plaintiff to their wrongful conduct, depriving plaintiff of rights described herein, knowingly, maliciously, and with conscious and reckless disregard for whether the rights of plaintiff would be violated by their acts and or omissions. Defendants' acts and or omissions were the moving force behind and proximately caused injuries and damages to plaintiff as set forth above. Defendant's conduct entitles plaintiff to punitive damages and penalties allowed under 42 U.S.C. Section 1983 and Nevada law in an amount sufficient to punish and deter such conduct. No punitive damages are sought against defendant Nevada. Third cause of action, 42 U.S.C. Section 1983, First Amendment, against Torres, Shoemaker, McCormick, and Doe's 1 through 25. By the actions and omissions described above, defendants acting under color of state law and in their individual capacities and as integral participants violated plaintiffs' rights under the First Amendment to the U.S. Constitution and equivalent rights under the Nevada State Constitution. In particular, defendants retaliated against plaintiff for his speech, including his verbal protests and criticisms of the defendant's actions in investigating, detaining, and arresting plaintiffs without any basis, his exercise of his right to refuse to cooperate in what started as a consensual encounter. And his exercise of his right to record police interactions, except there's time, place, and manner restrictions. And it can go from a consensual encounter to a non-consensual encounter really quick. Plaintiff also believes defendants retaliated against him for initially refusing to assist in their investigation, which is also protected under the First Amendment and equivalent rights under the Nevada State Constitution. what part of the First Amendment allows you to not identify yourself when you're detained by the police? I must have missed that section. Defendants subjected plaintiff to their wrongful conduct, depriving plaintiff of rights described herein, knowingly, maliciously, and with conscious and reckless disregard for whether the rights of plaintiff would be violated by their acts and or omissions. Defendants' acts and or omissions were the moving force behind and approximately caused injuries and damages to plaintiff as set forth above. Defendant's conduct entitles plaintiff to punitive damages and penalties allowable under 42 U.S.C. Section 1983 and Nevada law in an amount sufficient to punish and deter such conduct. No punitive damages are sought against Nevada. Fourth cause of action, 42 U.S.C. Section 1983, Monell and supervisor liability against LVMPD, Nevada, Torres, and Doe's 26 through 50. Hey, we're moving on up. The unconstitutional actions and or omissions of defendants Torres, Shoemaker, McCormick, and Doe's 1 through 25 were pursuant to the following customs policies, practices, and or procedures of defendant LVMPD and Nevada, and which were directed, encouraged, allowed, and or ratified by policy-making officials with Nevada and the LVMPD. A, to carry out or tolerate unlawful detentions without reasonable suspicion. B, to carry out or tolerate unlawful arrests without probable cause. C, to carry out or tolerate detentions and arrests based on citizens' refusal to cooperate with consensual encounters. D, to carry out or tolerate detentions and arrests based on citizens' exercise of their First Amendment right to criticize and verbally protest deputies' actions. E, to use or tolerate excessive force. F, to carry out or tolerate unlawful searches of persons and properties. G, to carry out or tolerate discriminatory or biased policing and or racial profiling. H, to fail to institute, require, and enforce proper and adequate training, supervision, policies, and procedures concerning each of the foregoing practices. I, to fail to institute, require, and enforce proper and adequate training, supervision, policies, and procedures within the LVMPD concerning the fear experienced by people of different skin color and other minorities, including cop-watching activists, when interacting with law enforcement in light of well-documented, highly publicized, and disproportionate amount of violence committed by law enforcement against said groups, and the tactics that LVMPD officers should employ in dealing with said groups. In light of such fears, especially where, as here, they have been explicitly made known to the officers. J, to ignore or fail to properly investigate, supervise, discipline, and or terminate officers who have engaged in unlawful or unconstitutional law enforcement activity. K, to allow officers to file false police reports. Defendant Nevada, LVMPD, and Doe's 26 through 50 failed to properly screen, hire, train, instruct, monitor, supervise, evaluate, investigate, discipline, and or terminate defendants Torres, Shoemaker, McCormick, and Doe's 1 through 25 with deliberate indifference to plaintiffs' constitutional rights. The unconstitutional actions of defendants Tory, McCormick, and Shoemaker, and Doe's 1 through 25 were approved, tolerated, and or ratified by policy-making officers for defendant Nevada and the LVMPD. The aforementioned customs, policies, practices, and procedures, and the failure to properly screen, hire, train, instruct, monitor, supervise, evaluate, investigate, discipline, and terminate, and the unconstitutional approval, ratification, and or toleration of the wrongful conduct of Torres, Shoemaker, McCormick, and Doe's 1 through 25 were a moving force and or proximate cause of the deprivation of plaintiffs' clearly established constitutional rights under the United States and the state of Nevada. As the supervisor on scene, defendants Torres, Shoemaker, and McCormick that as the supervisor on scene, supervisor would indicate singular one, but defendants Torres, Shoemaker, and McCormick, only one of whom is presumably a supervisor, but as the supervisor on scene, defendants Torres, Shoemaker, and McCormick had an obligation to ensure that their subordinates, including defendants Torres, Shoemaker, and McCormick, and does 1 through 25, who were not on scene, refrained from violating plaintiffs' constitutional rights and prevented other peace officers from violating plaintiffs' rights. Because Torres, Shoemaker, and McCormick learned and were apprised of the relevant facts surrounding the arrest and or detention of plaintiff, the use of force on plaintiff, and the search of his person and property, and because they knew that such actions were illegal and unconstitutional, Torres, Shoemaker, and McCormick were obligated to immediately terminate those unconstitutional actions, and by failing to do so, Torres, Shoemaker, and McCormick are liable in their role as a supervisor. As a direct and proximate result of defendant's conduct, plaintiff suffered injuries and damages set forth above. So, once again, I believe that section was entirely written by Delete Lawz. Why do I think that? Because it almost identically mirrors the same section from Delete Lawz lawsuit. So I absolutely believe it's the exact same thing. Fifth cause of action, 42 U.S. Code section 1981. Against Torres, Shoemaker, McCormick, and Does 1 through 25. In doing the things herein alleged, defendants intentionally discriminated against plaintiffs because of his race and political affiliations and viewpoints, thereby depriving him of his right to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by all other citizens. Defendants subjected plaintiff to their wrongful conduct, depriving plaintiff of rights described herein, knowingly, maliciously, and with conscious and reckless disregard for whether the rights of plaintiff would be violated by their acts and or omissions. Defendants' acts and or omissions were the moving force behind and proximately caused injuries and damages to plaintiff as set forth above. Defendants' conduct entitles plaintiff to punitive damages and penalties allowable under 42 U.S.C. section 1983, even though this is 1981. This cause of action is 1981, but apparently the damages and penalties are allowable under section 1983 and Nevada law, and in an amount sufficient to punish and deter such conduct. No punitive damages are sought against defendant Nevada. Sixth cause of action, assault against all defendants. In doing the things herein alleged, defendants intentionally and without consent or legal justification attempted to make a harmful and or offensive physical contact with plaintiff and thereby placed plaintiff in fear of an imminent harmful or offensive contact. As a direct and proximate result of defendant's conduct, plaintiff was harmed. Defendants Nevada and LVMPD are vicariously liable for the acts and omissions of their employees acting in the course and scope of said employment pursuant to NRS 41.032. The conduct of the individual defendants was malicious and oppressive in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable. Once again, my Daffy Duck impression. They were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. Sixth cause of action, battery against all defendants. Hey, it's almost like these are the exact same causes of action in the exact same order as in the Delete Lawz lawsuit. In doing the things herein alleged, defendants intentionally and without consent or legal justification touched plaintiff in a harmful and offensive manner. As a direct and proximate result of defendant's conduct, plaintiff suffered injuries and damages as set forth above. Just like Delete Lawz, he's going to have a real hard time claiming these injuries and damages, because just like Delete Lawz, I highly doubt that Floyd has any medical reports. That's kind of an important part. Defendants Nevada and LVMPD are vicariously liable for the acts and omissions of its employees acting in the course and scope of said employment, pursuant to NRS 42.005. The conduct of the individual defendants was malicious and oppressive in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. Speaking of Daffy Duck, I hope you guys know there are compilations on YouTube of classic Looney Tunes, like 5-hour, 6-hour long compilations that you can just put on and, enjoy a adult beverage of your choice and enjoy your afternoon. Eighth cause of action, false arrest and imprisonment against all defendants. In doing the things herein alleged, defendants intentionally arrested and or detained plaintiff without a warrant or legal justification, and in doing so restrained plaintiff, handcuffed him, and placed him in patrol cars against his will, thereby depriving him of his freedom of movement. But hey, if they arrest you on reasonable suspicion of a crime that they witnessed, they don't need a warrant. And if they have reasonable suspicion, it's not a false arrest or false imprisonment. Funny how that works. As a direct and proximate result of defendant's conduct, plaintiff suffered injuries and damages as set forth above. Except he hasn't set forth any injuries above. And he's not going to be able to because he wasn't injured. Defendants Nevada and LVMPD are vicariously liable for the acts and omissions of its employees acting in the course and scope of said employment pursuant to NRS 42.005. The conduct of the individual defendants was malicious and oppressive in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. Clearly, Daffy Duck has no interest in the eighth cause of action. It was merely despicable. Ninth cause of action, invasion of privacy. During the incident giving rise to this action, plaintiff had a reasonable expectation of privacy in his personal affairs, including the contents of his personal belongings, such as pockets, wallets, cell phones, and other electronic devices. In doing the things herein alleged, defendants intentionally invaded and intruded into plaintiff's personal and private affairs by searching his belongings without a warrant or other legal justification. That's called a search incident to arrest, which is legal. Defendant's invasion of plaintiff's privacy would have been offensive to any reasonable person. As a direct and proximate result of defendant's conduct, plaintiff was harmed. Defendants Nevada and LVMPD are vicariously liable for the acts and omissions of its employees acting in the course and scope of said employment, pursuant to NRS 42.005. The conduct of the individual defendants was malicious and oppressive in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. 10th cause of action, negligence against all defendants. I think this is the last one because we're on page 19 of 20, so this has got to be the last one. The individual defendants owed plaintiff a duty to use reasonable care in connection with the parties' interactions as described herein. In particular, said defendants had a duty to carefully investigate any criminal activity, to use care to avoid subjecting plaintiff to excessive force and illegal detention, arrest, seizure, retaliation for exercise of free speech, free press, or petition for redress of grievances, or deprivation of any of the other rights enumerated herein, and to use reasonable care to avoid engaging in biased policing or racial and political affiliation profiling. I at least give them credit here. They didn't say he was redressing government employees, but because the Constitution doesn't give you the right to redress government employees, it gives you the right to petition for redress of grievances. So I think I've said it before. It is one of my pet peeves. It's one of my major pet peeves with frauditors, other than them being such colossal jerks. We'll say jerks. In doing the things herein alleged, defendants breached the applicable duty of care by acting unreasonably, carelessly, negligently, and or recklessly. As a direct and proximate result of defendant's conduct, plaintiff suffered injuries and damages as set forth above. Defendants Nevada and LVMPD are vicariously liable for the acts and omissions of its employees acting in the course and scope of said employment, pursuant to NRS 42.005. The conduct of the individual defendants was malicious and oppressive in that they intended to harm plaintiff and deprive him of his rights, or their actions were despicable and carried out with a willful and conscious disregard for plaintiff's rights and safety, entitling plaintiff to punitive damages pursuant to NRS 42.005. No punitive damages are being sought against defendant Nevada. Prayer. Plaintiff prays for damages in as follows: for compensatory damages in an amount according to proof, for punitive damages in the amount of $2 million or in an amount sufficient to punish defendant's conduct and deter similar conduct in the future pursuant to 42 U.S.C. Section 1983. No punitive damages are sought against defendant Nevada. Yeah, he didn't suffer anywhere near $2 million of damages, even if his rights were violated, which they were not. This isn't a $2 million case. For all applicable statutory penalties for attorney's fees pursuant to 42 U.S.C. Section 1988. Like I said, 42 U.S.C. 1988. That allows for recovery of attorney's fees for civil rights cases. But unfortunately for Floyd, he's not going to collect those because he doesn't have an attorney. And while I understand that Delete Lawz almost assuredly wrote this heap of garbage, he's not eligible to collect attorney's fees. Imagine that. He wants costs of the suit and for such other and further relief as the court deems just and proper. Demand for jury trial. Plaintiff hereby demands a trial by jury. And declaration. I declare under penalty of perjury that the following is true and correct. And it's signed by Floyd, but I'm not going to scroll any farther down because I don't want to dox him. Although I highly doubt that's his actual address, but what are you going to do? So, like I said, I absolutely believe this was written by Delete Lawz. It's the exact same causes of action, the exact same reasoning, except adding that Floyd is black, which leads me to believe that's why Delete Lawz probably reached out to Floyd specifically, is my guess, because not that there are many auditors that actually like Delete Lawz. You know, he wasn't going to be able to get Denver Metro audits or Long Island audits or probably even Glenn Serio or really anyone. I doubt PayPal Patty likes him. But Floyd, hey, he's more than happy to risk a lead sandwich to benefit some other frauditor. So it's just a win-win for Delete Lawz to get Floyd to go and harass the exact police substation that Delete Lawz has been harassing for months. I raced through the causes of action. So for those of you who are new, and I should have said this at the beginning, because I like to say it when I begin a new case. I'm Joe. I'm an attorney licensed in the state of Utah. So I'm very close to Nevada, but I am not a Nevada licensed attorney, just Utah. And I lost my train of thought. Why did I lose my train of thought? That is obnoxious. Oh, yeah. So I raced through the causes of action in this. If you are new here and didn't watch my coverage of Delete Lawz, virtually identical complaint, go and watch that. It's about a month old. It's, I think, titled, or at least the thumbnail, What Happens in Vegas. I go in a little bit more detail in the causes of action. But like I said, they're the same here. So for those of you who have watched both videos, you've seen my analysis already. For those of you who haven't, go watch that video. It's, you know, it's about the same as this one. With that, I'm surprised under an hour and 20 minutes. That's pretty good, but that's because I was racing through it. I will hopefully see you guys tomorrow to discuss Blue Bacon's anti-slap motion. That should be fun. And yeah, do all the YouTube things on your way out. Do all the like, share, subscribe, and thanks for joining me. See ya.